Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to circle back now to a bunch of consolidated cases, all stemming from Illinois' rather sinister and maniacal assault weapon ban that got shoved down their citizens' throats a couple of years ago. There has been a litany of challenges, and a bunch of them now have been consolidated before the 7th Circuit Court of Appeals. I know all of you are celebrating to hear that. It's a lot like being in front of the 9th Circuit. We're going to focus on an Amicus brief today because I think it really hits a home run with some points. Plus, it's authored by one of my favorite brief writers. So today, let's spend a few minutes and let's talk about maybe this is why everyone should have an AR-15. Okay, America, we're talking about the challenge to the Protect Illinois Communities Act. We have covered this statute. We had covered the trials and tribulations of the good folks out there in Illinois who has a state government that absolutely hates them. There are many cases consolidated on it, but the lead case, the title case, is Barnett v. Raoul. We've talked about that case as well. The Amicus brief that we're going to be sharing with you today is written by Mr. Barry Arrington of the National Association for Gun Rights. And yes, I do thoroughly enjoy Barry's briefs for multiple reasons. Number one, they are in fact brief. I like that. Brief is good. Number two, they are incredibly witty, oftentimes very funny, and Barry is a real good wordsmith. And so he lays out 4 arguments here that I think really begs the question, hey, is the AR-15, is the assault weapon actually more protected than the handgun? Because he raises some really good points. The points that Barry is arguing on behalf of NAGR and on behalf of lawful and responsible gun owners throughout the entire state of Illinois is, number one, the court should reject this cramped conception of the right to self-defense. Number two, a proper understanding of the Second Amendment reveals that AR-15s have greater protection than handguns. Number three, arms useful for resistance are at the top of the hierarchy of protected weapons. And number 4, Smith & Wesson v. Mexico answers all of this already. Now, one of the biggest threats to all of our Second Amendment rights is this bastardization of the in common use test, because now courts such as the 7th Circuit call it in common use for self-defense. Then they get to inject the balancing test and say, well, we don't believe that this firearm is appropriate for self-defense, so you don't get it. As Mr. Arrington points out, this cramped conception of the scope of the right to self-defense is inconsistent with the right to keep and bear arms protected by the Second Amendment. The right to self-defense codified in that amendment is not restricted to personal defense against criminal attacks. And you sit there and you go, well, what else is it for? Well, you see, the Second Amendment is there actually to protect you from 2 types of violence. One is private violence, and that's the stuff we read about in the papers and see on the news all the time. That's your robberies, your muggings, your sexual assaults, and things such as that. And yes, the Second Amendment absolutely positively guarantees the right of self-preservation from that. But you know what else it guarantees, and in some ways probably even guarantees it more? Yeah, the right to be able to resist a tyrannical government, the right to be able to combat and overthrow a tyrannical government. As Mr. Arrington wisely points out, yes, the right to keep and bear arms encompasses the right to defend against a criminal attack, private violence. But it also encompasses the right to defend against government tyranny, as at Lexington and Concord, and the unchecked predations of lawless mobs, public violence. And if you doubt that for 1 second, let's just go back in our time machine and let's consider when the Second Amendment was ratified. What was it that the colonists had just overcome? Oh, that's right, a tyrannical government. Yeah, so do you think that they were concerned about muggings on the street, or do you think they were concerned about the fact that the government they were forming could become as tyrannical as the government they just had to overthrow? As the Amicus party points out here, it was understood at the time the Second Amendment was ratified that the right to self-defense encompasses the right of citizens to hold sufficient arms to keep the government in awe of their power, lest that government be tempted to slip its constitutional bonds. You see, folks, the Second Amendment is not really there to protect your freedoms. No, it's there to protect something far more important than your freedoms, and that's your liberty, the ability to live the exact life that you've chosen for you and your family. And as a wise scholar once noted, Disarm a community and you rob them of the means of defending life. Take away their weapons of defense and you take away the inalienable right of defending liberty. And so with that very clear historical context, Amicus Party comes to this conclusion. In summary, Heller held the right to keep and bear arms protects citizens' right to self-defense. The right to self-defense includes the right to have arms for the purpose of resistance and defense. Defense against public violence and self-preservation. Defense against private violence. Now, a second argument he makes is that a proper understanding of the Second Amendment reveals that AR-15s have actually greater protection than handguns. And of course, this entire in common use for self-defense or more appropriate for military use or any of these other bastardized tests that have just been created out of thin air does nothing more than absolutely eviscerate the Second Amendment protections. As Amicus Counsel correctly points out, the government's laser focus on the Second Amendment's protection of the right to self-defense against private criminal conduct to the exclusion of the amendment's protection of the right to defend against public violence is ironic because it turns the original primary purpose of the Second Amendment on its head. You cannot convince me that the biggest concern of our founding fathers when they ratified our Constitution was, I might get mugged in the park someday, or my wife might be sexually assaulted by an illegal immigrant someday. That was not the concern of the original founding fathers. No, the concern was actually something that had just occurred. A tyrannical government that was inflicting its will upon the people, where the colonists had to stand up and say, you know what, enough. As counsel points out, the founders' preoccupation with preserving the right to keep and bear arms for the purpose of collective action against tyrannical government has implications for the hierarchy of weapons protected by the Second Amendment. Surely those arms most useful for collective resistance would be at the top of that hierarchy. And quoting from another memorandum sponsored by another one of my favorite brief writers, of course that is Costas Moros, Mr. Arrington points out, people do not typically resist a tyrant with small pistols or slow-firing hunting rifles, which even governments have acknowledged when faced with invasion and distributing weapons to civilians. Resistors do it with the prevailing common long gun of the day, AR-15s and other similar so-called assault weapons that are owned by millions of regular citizens across the country. These are the sorts of lawful weapons that they possessed at home that would be brought to bear in the horrible circumstance of a tyrant upsetting our constitutional order or a foreign invader occupying our country. Not like we would ever have foreign invaders occupying our country, right? Or have a political party saying that one person's just being a complete tyrant. Not like that would ever happen either. But for the Jerry Nadlers of the world who can't just seem to get their head around the fact that, yeah, the Second Amendment is there to protect us from our government, Mr. Arrington again correctly points out, some might say that defense against tyranny is no longer necessary and therefore protecting the weapons most useful for resistance is not a priority. But no society, even an advanced liberal democracy, is immune to human nature. Listen, if you actually take a look at the case law, and you take a look at what was expected of militia members, which is to be able to arrive for duty with the most modern and effective weapon imaginable at that time, one could actually argue that maybe we're entitled to access to a far larger swath of firearms, such as automatic weapons, than what the federal government currently allows us to possess. And then finally, and we talked about it on this video right here, Mr. Arrington wisely points out that Smith & Wesson v. Mexico is dispositive on the AR-15 and AK-47 issue. Because it all comes down to the common use test. And the common use test is a very simple test. It's one that's based on numerical value. Are the firearms in common use for any lawful purpose? Self-defense being one of them. So is collecting. Okay, that's a lawful purpose as well. But let us also remember that in the recent case of Smith & Wesson v. Mexico, where Mexico took an absolute trouncing 9-0 at the hands of the Supreme Court, Justice Elena Kagan was quoted as saying, "But those products are widely legal and bought by many ordinary consumers. The AR-15 is the most popular rifle in the country." Which, of course, leads Mr. Arrington to the obvious conclusion, Smith & Wesson Brands, Inc. is absolutely dispositive on the issue of whether AR-15 rifles and AK-47 rifles are protected by the Second Amendment. Because they are in common use by ordinary citizens, they are protected. So listen, a very concise, well-written brief that points out 4 very, very convincing arguments. We're going to link it up down below so you guys don't have to take our word for it. You can just geek out on it for yourself. The case, once again, Illinois, is Barnett v. Raoul. There will be many other amicus briefs coming in on it. This is going to be a big fat Donnybrook in which the 7th Circuit will inevitably uphold the Protect Illinois Communities Act, and then we'll be on the watch watching these cases petitioned to the United States Supreme Court. Don't hold your breath. Listen, if you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information's down there in the description box. If you got an idea for a video we should be doing around here, we want to hear all about it by you clicking on that link right there and telling us all about it. If you want to subscribe to the monthly newsletter, down there in the description box is all the information on how to do that. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.